Hello everyone, GM. Welcome back to another episode of Overpriced JPEGs. I am so excited for today's episode. More excited than even usual, I would say, because this is a conversation I've wanted to have for a really long time, which is diving deeper into the guts of US securities laws, which hopefully sounds as fun to you as it sounds to me. And I did something like this last year where I did a roundtable of lawyers, of intellectual property lawyers, to really break down IP law, copyright, trademark, CC0, which was something being talked about a lot at the time. And I personally found it super valuable. And it was also one of my better received episodes. I got a lot of really positive feedback from people on it. So I'm hoping folks will really enjoy this as well. And I wanted to make sure we were anchoring this conversation in some recent real world events so that this didn't just feel like a law school class that nobody wanted to take and we weren't just speaking in the theoretical. So we really dive into the judge's decision in the Ripple case, and we talk a bit about Prometheum, which has been on crypto Twitter a bit lately for primarily controversial reasons. And while there's plenty of conversation and breakdowns that you can find of the Ripple verdict, I felt like this conversation both dug a little deeper and went some places that I personally still had a lot of question marks around, even after having listened to a number of other podcasts or takes about the Ripple verdict. So I hope you'll learn something broader about securities laws, about what's happening in today's landscape than you maybe have elsewhere. And finally, this is likely going to be a part one of what looks like it might be a two-part series. In this episode, I sit down with Karen Ubel, who is a partner at Goodwin & Procter. She leads up their blockchain division. She was also an attorney at the SEC for 6 years. So she is incredibly well placed to talk about everything we get into today from her legal perspective on the blockchain and on cryptocurrencies, to also how we should understand the SEC's movements today. Of course, she does not represent the SEC in anything. She hasn't worked there for a number of years. She also, of course, is not providing any concrete legal advice here, but her perspective is super, super valuable. So with that, I hope you enjoyed today's conversation, and we are going to get to it right after this word from our amazing sponsors who make the show possible.
Y'all know the phrase, not your keys, not your crypto. Well, in a world where too many people have had to learn that the hard way, Overpriced JPEGs is proud to partner with Ledger, the world leader in critical digital asset security. Ledger's Nano S Plus and Nano X hardware wallets, paired with the Ledger Live app, Ledger's own software for setting up your Nano device and managing your crypto assets, is the easiest way to start your crypto journey while maintaining full control of your digital assets. You can use all your favorite dApps with Ledger Live, accessing 15 plus Web3 apps, including 1inch, Paraswap, Lido, and Zerion. So you can not only manage, but also grow your portfolio. And Ledger Live is available on mobile and desktop. Securing digital assets shouldn't be complicated. Ledger is as easy as it gets. Uncompromising security, effortless connectivity, full transparency, Ledger is your one-stop shop to trade and track crypto, grow your assets, and manage NFTs. Secure your future with Ledger. Visit shop.ledger.com today or check out the link in the show notes. I am so excited to announce that this year, Overpriced JPEGs has partnered with OPENSEA, the world's leading NFT marketplace, built for everyone, creators, collectors, noobs, and experts alike. I'm an OPENSEA user because they have the best selection of NFTs and a truly inclusive view of the ecosystem, supporting 8 chains and 8 global languages. I trust the systems they've put in place to keep the space safe, like copyright protection, malicious URL detection and removal, robust verification, and more. It's why they are the place to buy, sell, and create NFTs. That's right. You know OPENSEA, you use OPENSEA, but did you know that OPENSEA now has drops? New exclusive projects launch every week from top projects and creators, and you can check them out now using the link in the show notes. They also recently introduced self-serve drops, which is in beta, and allows creators to launch their projects right on OPENSEA. This drops product gives creators access to tools like rich storytelling drop pages, multi-chain support, and drop mechanic customization. The full launch for self-serve drops is coming this spring. So check out the upcoming drops on OPENSEA right now using the link in the show notes and own what moves you. You'll also be supporting the show in the process. Karen Ubel, welcome back to Overpriced JPEGs.
Great to be back. Great to see you again.
I know you have some disclaimers up top. We usually have our not financial advice disclaimer. I think you have a not legal advice disclaimer you want to give here.
That's right. I am a lawyer, but this is not legal advice. You are not my client. If you need legal advice, you should consult a lawyer. Anything I say here, obviously, are my own personal views and not the views of my partners at Goodwin or any of my clients.
She's a lawyer, but she's not your lawyer. So get your lawyer.
Right.
Excellent. I said this in my intro, but what we're trying to do here, I think, is tease out and better understand the nuances, the complexities of existing U.S. securities laws by anchoring in what's going on with Prometheum and what's going on with this Ripple case. And now we actually just had a judge counter what Judge Torres had said in the Ripple case, which I think we'll get to at some point here. So there's a lot going on, but let's really anchor this conversation in those things to make it a little bit less head spinny for folks. So where I'd love to start is just level setting on the Ripple case. So my layperson's articulation of what the takeaways were there is that Judge Torres said that when Ripple issued these tokens to sophisticated investors, essentially early investors, that was a security issuance and they violated securities laws by not registering that. But when they issued tokens to the general public via whatever it was, a marketplace, which she calls, I think, programmatic sales, that was not an illegal securities issuances and they were not securities in that context. Is that fair? Is that right?
Yeah, that was the gist of the ruling, but getting into the details of it, I think is what's really important to think about what the right takeaways are from this ruling. And I think that the really important part to me of this case was that Judge Torres said XRP, the token, is not in and of itself as a security. This is not in and of itself a security. We have heard that before from other judges, but we have heard Gary Gensler and the SEC beating a very different drum. They're trying to create a concept of a crypto asset security, which is the token itself embodies the investment contract. And she importantly and correctly, in my view, rejects that idea. The token is code. The token is a currency. The token is an orange, right? Like that, I'll come back to that idea. Think about this. If it were an orange, how would we think about this? And so then what you do is you go through and you have to say, look at the manner of sale. How was this offered? And in reviewing those facts, all the totality and facts of circumstances, is there an investment contract in those cases? Are the four prongs of the Howey test met such that transaction and all the facts surrounding it constitute an investment contract? And so what she said is that in certain instances, the facts support, yes, the Howey factors were there. This is an investment contract, therefore it's a securities transaction. And in other cases, those facts did not support all four factors of the Howey test. And so it wasn't an investment contract, so therefore it wasn't a security and is not regulated by the SEC. And so that's, I think, the most important element of this decision. Unfortunately, we've seen it already called into question, and so we'll see how long it continues to stand. But I really do think that this is the important part here, is that oranges, when you sell them in the grocery store, are not securities. Oranges, when you sell them on the street corner, are not securities. Orange seeds are not securities. But if you sell orange groves and orange seeds with a promise to grow the trees, water the trees, harvest the oranges, sell the oranges, and then just return the profits to the people that you had those contracts with, then that's an investment contract. And I think that was really important.
And you're referring to, that was like the seminal case that
Howey test,
launched the Howey test, correct? Right. Okay, so that's the basic principle. And then it was, the way she applied it was making this distinction between institutional investors and these programmatic sales. Walk us through the different categories she identified.
Yeah, and so that's the idea here, right? Is you're taking each type of sale and each manner of sale and evaluating the Howey test factors to see whether or not there was an expectation of profit from the efforts of others with following an investment of money in a common enterprise. And so what she did say is that institutional sales that Ripple engaged in getting sold to large institutional investors, they gave them slide decks, they gave them updates on the growth of the ecosystem, a lot of direct marketing specifically to them, a lot of engagement with those institutional investors. They invested money, went into the company. The company then, Ripple used that to further grow and develop the XRP ecosystem and then the Ripple community. So in those cases, what she said is there was clearly an investment of money. There was an expectation of profits because they thought they would be able to resell these, and they were told they could resell them, and that they were expecting the company, Ripple, to pool those funds to further develop the ecosystem and increase demand and adoption, et cetera, et cetera. So in those cases, she said the Howey factors are met. This was an investment contract, and therefore it's a securities transaction that needed to either be registered or exempt. In the programmatic sales, she again started anew. Here are the new facts. This is a different set of facts and circumstances. The company, Ripple, was selling through an exchange, through transactions where, in her view, if you were a retail investor coming onto an exchange in a bid-ask typical blind sale, you don't know who's on the other side of that. It could be anybody who previously had Ripple XRP that they had purchased from the company, or it could be Ripple in this case. And so her view was that there was an investment of money, but nobody knew that it was actually going to the company. So that first prong was maybe not necessarily satisfied, because while the money was going in, you weren't giving it to them in the expectation that they would be using it to further develop the network and the ecosystem and create value, because you didn't even know that they were receiving the money. And then she also said that the 8 years of communications and interview, different in her view, obviously differentiating investor decks and investor meetings and roadshows, interviews and tweets and things like that by the company's CEO and things like that were viewed differently, not targeted marketing and advertising to those retail investors. And so they would not necessarily know that someone out there had promised or was putting in those efforts. And so those Howey prongs were not met. There was another one in there too, though, where they were using XRP to compensate employees or to provide bounties to people that were finding problems in the XRP system, or for partners and partnerships. And in that case, she actually started at the very beginning again and said, actually, there's no investment of money. First prong, the Howey test wasn't even met. We don't have an investment contract.
Yeah, so that makes sense. But what I've been hearing is the pushback to that is then, why are stocks we trade on the stock exchange still securities? Because I'm not buying that from Meta. I didn't buy a share of Meta from Meta the last time I bought Meta stock. How do you reconcile those two things?
Yeah, I think the really important thing to remember, and this is, only a securities law wonk, probably knows how to dive this deep, but common stock, equity securities, notes, things like that, those are enumerated securities. Investment contract is also an enumerated security. So in the Securities Act, in Section 2A1, it says these things are securities. And we all know common stock is an equity security. There's no question that when you sell or offer or buy common stock, that is a transaction in a security. It is regulated by the federal securities laws. Investment contract, on the other hand, we don't know what that is, and it's not an investment contract unless you have satisfied the Howey test factors. And so the point here is that every transaction in common stock will always be a security. Not every transaction in tokens will be an investment contract and therefore be a security. You have to look at those Howey factor prongs to establish that they're met, and therefore it was a securities transaction, and therefore compliance with the securities laws needs to occur.
This investment contract piece is huge, and we last time you were on this show, we talked about it a little bit, because there's this question around like distinguishing between the investment contract, which in a lot of these cases was like a SAFT or a warrant, and we'll get into that, and then there's these tokens kind of get issued pursuant to those things. And so there's this separation between the token and then the thing that may have been the initial investment contract. And if people's heads are spinning, I promise we'll walk through that more clearly than I just did here. But I'm just saying that to say, let's put a pin in that for a minute, because I want to press on this issue. I guess it feels like strange logic where, could you use Judge Torres's logic in her ruling to file a lawsuit against I don't know who to say that, based on this, it's no longer true that secondary sales of this common stock equity are actually securities? No,
because every transaction in common stock is a transaction in an equity security.
But here's my question. If you reapplied the Howey test to a share of Meta right now, to me, by the logic that Judge Torres puts forth, it would not pass it wouldn't be a security according to the Howey test.
But so there, in the Securities Act, there's a list of items that are securities. equity securities are a security, right? And you don't have to apply the Howey test to the offer and sale because we know every transaction in common stock is a transaction in an equity security, which is named in the list, in the statute of these are the things that the SEC has the authority to regulate. And the challenge here is that an investment contract is also enumerated, but we don't know, nobody really knew, okay, what is an investment contract? The Howey test in the Supreme Court said, here's what is an investment contract, and you have to take these factors into account to determine whether it's an investment contract. Check the box. I've checked all the 4 Howey test factors. Now I'm an investment contract. Now I'm regulated as a security. There's no manner of sale considerations when you're selling common stock, right? Because it doesn't have those 4-factor tests. Now, notes is another example where sometimes a note, like your mortgage, is not a security when it's repacked. But other notes, like debt, there are debt capital markets, right? Those are securities. And there is a different test established by state case law on whether a note is or is not a security. That's what I'm saying here is that common stock doesn't get to go through the Howey test factors.
Okay.
Already
all right.
Security.
This is really helpful, and I don't know if everybody just picked up on this, but I just had my aha moment. So what you're saying is there's a law, a statute, a law, whatever it is, that oversees and regulates securities writ large.
Yep.
It lists out, and I think this is where you used the word enumerate earlier, and my brain started spinning around thinking that you were talking about like we were numbering the stocks, but that's not what I don't think. And now in hindsight, I don't think that's what you meant. What you're saying is there's this statute, there's this law that enumerates what constitutes a security. And that's a list of 5 or 6 things, whatever the number is. In that list is stocks, just what you're going to find on a stock exchange, equity securities, and so there's no additional test you apply. If you are an equity security, we're done.
Actually, I take it back. I'm looking at the statute right now. Note, stock, treasury stock, security-based swap, evidence of indebtedness, certificate of participation and profit sharing, things like that, on. And then
okay, so there's a whole list, and within that list is investment contract.
Yes.
And so let me ask, and then now if we drill down further with an investment contract, that's where then Howey is applied.
Yes.
Howey is not just applied broadly to everything in that securities list. It's specifically something that is meant to apply to an investment contract, which is one thing that's a security within there. And then how do you determine if an investment contract? Okay, it's all coming together. So let me ask you this, and I don't want to take us too far down this rabbit hole, but like, how did we determine that digital assets fell in that investment contract category and not another category?
That was essentially a world in which people are investing a lot of money into digital assets. And so we had to figure out who might be the regulator here. And back in the initial stages of this, it seemed that it was likely the SEC would emerge as the regulator. And so you had to decide whether or not, hey, is this a security? What is the appropriate test to determine whether or not it's a security? And as you'll see, with just because, for example, oranges, beavers, whiskey, barrels, all of these things can be the subject of investment contracts that historically have then been called securities. That was, I think, at the very beginning of this, we all in the legal community thought, okay, that's the hook through which the SEC would try and come and regulate this. Because it's not, while stock is specifically listed in Section 2A1 of the 33 Act, there actually is even case law that says what is stock? What are the hallmarks of stock, right? And an equity security. And there is case law that has evolved around that. I think there's not a lot of question usually because you usually have a certificate that at the top it says stock. But there are instances in which it has been litigated as to whether something that had voting rights and paid dividends and things like that. So that's why, again, as we're designing tokens, we're taking those factors into account, whether it could be viewed as stock or whether it could be viewed as a note and whether it could be viewed as an investment contract.
In some ways, what I hear you saying is it's almost like the SEC is the one who said this is an investment contract because they looked at the things that were under their purview and they're like, we really probably can't call this stock. We can't call it this. We can't call it that. Investment contracts are under our purview. We're going to say it's an investment contract.
I think that's right. I think also just again when there were, and this goes to some of the comments that have been made about back in the day that we were all trying to evade securities laws. No, we actually, as lawyers in the space, were trying to say, okay, if it has these features, then it would be considered a security. So how do these things work, and how is it different than a typical investment contract, which in our view, they always have been, there's guidance out there that things that have utility, things that are used in commerce, all of these factors that undermine the investment contract analysis, that's what we viewed as being important and prevalent, but we anticipated that this was the hook that the SEC would try to use to bring it under its jurisdiction.
Mm-hmm. So let's continue to poke a little bit at this ruling, because that is helpful. I feel like a lot has been clarified for me in my own brain about this and in what we just talked about, but I'm still a little nervous. There is something that still feels a little bit strange because the sophisticated investors got decks and actually read stuff, it's a security, but because the idiots who just trade this stuff like shit coins didn't read any of that, it's not a security. That feels like a tenuous kind of a logic on which to build this off of. Frankly, if she had said there's utility to this and that differentiates it, that would have made me feel better, but I don't think we really saw that in her ruling. Speak to your feeling on that, and maybe it's a good moment for you to bring in and just explain to us briefly what this other judge, who has now basically directly refuted Judge Torres's ruling, has said.
Yeah, I think that's right. I think that it's a unusual result to find yourself in a position that the poor retail investors are not entitled to.
We're just too stupid to have this be a security because we just don't know what we're buying.
Where investors should get that. Now, that being said, I think that in looking even at this newest ruling with Terra Luna from Judge Rakoff, I think was who it was, because I think what that judge expressed is that with the Terra Luna process, there was so much targeted heavy marketing in the facts that he assumed into the motion to dismiss order, that targeting 20% returns and really a lot of really targeted efforts to bring retail investors into the ecosystem. It might be a little bit different. You could argue that was maybe how it was differentiated between Judge Torres, when you're providing something that's very clearly showing and demonstrating a potential return. When you're whoever you're targeting that kind of information to, then that is enough to establish that expectation of profits. I think that may be something that we could differentiate between because the marketing efforts were just so heavy with Terra Luna on, here's your 20% return for putting your Luna into UST and things like that.
Let me introduce you to a brand new company that I could not be more excited about, Web3 Sense. A Web3 analytics platform that combines on-chain data with social media insights to give you the deepest, most meaningful intelligence into any NFT community. I have tested other analytics platforms out there, but Web3 Sense has the most comprehensive capabilities I've seen in the NFT ecosystem. They apply sophisticated data science to wallet histories to determine behavioral patterns and help shape predictive analytics. In other words, they can tell you which Twitter accounts are actually the influencers in your space. And they can tell you what resonates most within a community by looking at what other communities token holders are involved in. The number of use cases here is virtually unlimited. So whether you're a trader, creator, institution, brand, agency, I promise Web3 Sense has data that you want to see with the deep and actionable insights that you need to build, analyze, grow, start, whatever you want to do within the NFT space and in terms of building a business and a community. Now, they are still in very early days, so they're eager to connect with the community. So if you're interested in learning more about what Web3 Sense can do for you and your business, and you should be, go and fill out the very short form linked to in the show notes, and someone from their team will reach out with more information and an opportunity for a product demo. Trust me, you won't regret it. It feels like one of the central debates, and this comes in with Prometheum a lot, and I referenced this earlier, is this idea of whether or not the tokens themselves are separate from the investment contracts. Because as we established, investment contracts, if it passes the Howey test, it's an investment contract, and that is regulated by the SEC. So the question is, are these tokens themselves investment contracts, or are these two separate pieces? To get us into this conversation, I want to play a clip from this episode on Unchained. Laura Shin moderated this conversation between Rodrigo Sega and Aaron Kaplan of Prometheum, where they're having this debate about essentially, is the token itself the investment contract, or are these two separate things? And so just to give a little context before we get into this, this clip starts with Rodrigo Sega refuting something that Aaron has just said. And what they're talking about in this context is there are these certain projects have filed these Form Ds in connection with their financing. And so there's a question of what is actually the investment contract there? Are they these warrants? Are they these SAFs, or are they the tokens? I think it'll be clear once we listen to this clip, and then Karen and I will talk about it. Let's take a listen.
So I think Aaron is wrong about this. He's right that certain projects have filed Form Ds in connection with financings. But if you look at those Form Ds, all of them were filed for actually convertible instruments, such like a SAF or a warrant, which are distinguishable from any token that can be issued pursuant to them. And
but is it not a security? Is that instrument not a security? That instrument's a security, right, Rodrigo?
Well, let me finish, Aaron. Yes, the SAF is a security, but the tokens themselves were designed with the explicit intent that they are not securities. So I don't think it's right to take the position that just because a project filed a Form D for a financing, that then a token that is subsequently issued is itself a security and that was issued pursuant to an exemption.
So hopefully that was clear to some folks. This is, again, this is centered on a very specific set of projects, but this idea that the investment contract was the SAFT or the warrant, and that these tokens are something separate. Karen, you brought this up the last time you were here. I didn't understand it last time. I think I have a better understanding of it now, but maybe break this down a little bit for folks and explain what's happening here.
So as somebody who helped write the original SAFT white paper, this is near and dear to my heart. SAFTs were, again, I was at the SEC before I came into private practice when Winklevoss filed the Bitcoin ETF. We literally went into a room, we looked at Bitcoin, and we applied the Howey test to it, right? So back to your question of how do we know that the SEC would probably apply the Howey test? Because I was in the room when we applied the Howey test to Bitcoin, right? So we knew that would be the hook and then the lens through which they were looking at this. And really, when you look at the SAFT white paper, it was essentially saying, yeah, when you have a pre-functional token, and this was in response to a lot of the ICOs that were happening where you had a white paper and a smile and nothing else, and $30 million about 10 minutes later. We were saying, how do we get this industry really into a little bit more of a compliant place? And so we said, all right, in those instances, if you apply the Howey test, the token still has to be developed. The network has to be developed. Those are efforts of others where you've got the investment of money from the expectation of profits of the efforts of others. So that looked like a security. So at that point in time, if you sold a token, there would be an implicit investment contract there because there was still more to do. So let's paper that. Let's have a piece of paper in the form of a SAFT that says, okay, here is the investment contract. Tokens are not the investment contract. Tokens are tokens. They are code, or even at that point in time, they didn't even exist when people sold SAFs. You have an investment contract that says, here to you all, you accredited investors, I'm selling these to you pursuant to an exemption. And this is a forward contract. It's not actually a convertible instrument. It's actually a forward contract. It said, you're paying for the right to receive in the future tokens when we are ready to launch them, where there are no further efforts of others required.
I want to interject because I just want to make a key point there where you're basically saying at that point, because you're at such an early stage, there's all this quote unquote effort of others that's still going to have to happen,
right,
to launch a token essentially. And so that's why you're at this moment where there is something that is an investment. You need something that is an investment contract because there's still a lot of efforts of others. But you're saying down the line, once you issue the token, now it's much more out of your hands. Now there's not that same question of efforts of others or efforts of you, the initial issuer. And that thing shouldn't be an investment contract. But we need some way to identify that in this founding moment, there's something that is an investment contract. So let's have a physical instrument that is that investment contract. And that's the SAFT. I don't know if I just made that any clearer to anybody else, but I understand it now.
No, but that's exactly right. So we said, all right, let's paper this as something. Let's paper it as a SAFT. The SAFT was a forward contract. It's a contract for you're paying now for delivery of something in the future, paying now for delivery of that token in the future at a time when it is no longer or should no longer be deemed and viewed to be a security. Sold it
and this is while you were at the SEC. This was an SEC.
I was in private practice.
Oh, this was later. This was later. Okay.
Yeah. But so basically that was the idea. And so that you took the time, you took the funds, and you used them to build out the functionality, build out the ecosystem, all of those things, such that when you delivered the tokens pursuant to the SAFT, they should no longer be deemed an investment contract or a scheme because it was no longer either they had utility and functionality, so there was no expectation of profits, people were buying them to use them, or there was no efforts of others in decentralized world, right? Where there is no longer anybody actually single or entity or person who is responsible for the success or failure of that token in that project. So that was the idea. So I think going back to what Aaron and Rodrigo were debating, is there was a Form D filed for the SAFT or a warrant or some other instrument, and that was the security, the representative investment contract. It did not make the tokens securities, as Aaron is trying to suggest. If he were trying to create a secondary market in SAFs, he could do that because that is what the exempt security was that was covered by the Form D. But I think, again, this just goes, and I know that Prometheum has been in a lot of talks with the SEC, but I think it goes to that concept that the SEC is trying to set forth, which is that the token itself embodies the investment contract, which is what Judge Torres rejected. What I think if you put it in the context of oranges don't embody an investment contract, they're a piece of fruit, right? Same idea.
There's three different things I want to say here. You're bringing up so much that's really interesting. And the first thing I just want to really hammer home, because I found Aaron so unbelievably condescending throughout this whole interview, is Judge Torres, despite Aaron's insistence in this, isn't that an investment contract? Isn't that an investment contract? As we just heard him saying, Judge Torres has rejected that idea. Then getting to this Orange Grove piece, because I think this is where it starts to crystallize for me a little bit better, which is you made that analogy. And again, this was the case that birthed Howey, which is oranges are commodities, right? Oranges themselves, clearly nobody's going to argue that those are securities. However, if you sell an investment contract and a plot of land that yields oranges, and then you sell the oranges and make a profit and give that profit back to somebody who made that initial investment, okay, that investment contract now clearly is a security and it's centered around oranges, but the oranges themselves are not the securities. Here's, I think, the better analogy here, and this is where I want to get your take. If I sold an investment contract in a plot of land where I was planting orange groves, and then I gave a bunch of those oranges to the person who invested in my orange grove plot, your point is those oranges still aren't the security.
Yeah.
And that's exactly what we're talking about here. Even if that person then went and sold the oranges off and made some money off those oranges.
Yeah, it becomes it's a hard analogy because oranges are always oranges. I guess they're on the tree and then they're in a bushel. But because I think there is clear evidence that both from the SEC and judges, this idea that a token can be offered and sold in a way that is a security investment contract transaction, and later in a transaction that is not that. Even with Judge Torres, she said with the institutional investors that even when they resell those tokens, she did not think that those would be viewed as investment contracts at that point in time because of the nature of how they were being sold and resold. So it's hard, it's a little bit difficult with oranges because they're literally physically something that we can hold in our hand and eat. But I think that's the idea, right? Is that if the contract was just to deliver oranges, that's actually a forward purchase contract, right? Not a securities transaction. You're saying, I'm going to pay you now for these oranges that you're going to produce, and you're going to deliver me all of the oranges that this orange grove produces. And then I'm going to sell those oranges because those oranges, so that is a forward purchase contract.
That's still really helpful. Yeah, that's helpful because it's not, the expectation of profit means money in this case, right? The profit can't be in the form of oranges, it feels. Putting a pin in this, I think I understand with what you just said. Here's where it feels like it gets dicey to me, and where maybe I'm playing devil's advocate. So you describe this moment when there's the creation of the SAFT, because you're saying, okay, the SAFT is the investment contract, but down the line, these tokens are completed entities, so to speak. We're past this point of efforts of others. So the token now no longer passes the Howey test. It is not a security. Except that, of course, plenty of these tokens go to market. And there's still plenty of effort being put in by the original issuer or others to build up the network to make the token worth more. So it's not really like the efforts of others does truly end once the token is live in the world. How do you address that problem, and does that make this thornier?
Truly what we grapple with as we try to figure out how to launch tokens and distribute tokens. But I think that what you're talking about is truly the concept of decentralization, if you're saying others and it's not one, it's not in Bill Hinman's speech when he was head of the Division of Corporation Finance, his comment was, is there a single person or entity upon which the success or failure of the enterprise depends? And so even with the example that you gave, the idea here is that there are many. And I think an analogy that we often use is there's two different ways to decentralize. One of them is to launch and take your hands off the wheel. And another could be not to take your hands off the wheel, but there are now so many hands on the wheel that nobody's really driving, right? Because if there are a number of different integrations, a number of different contributors, there's the validators, all of the different pieces of that puzzle, you're at a point now where this looks like a functioning kind of commodities market in many ways. There are all these different things that are contributing to the value. It's not the issuer of the token, the sponsor of the token, the people that wrote the original software code. It's a number of different people, and that's not what the Howey test contemplates. The Howey test contemplates, I give money to you, you exert your efforts, I receive profit from those efforts. And when you is a decentralized group of individuals, that's no longer, in my view, that no longer satisfies that prong in the Howey test.
Now, what's interesting is the way it's phrased is others, right? It doesn't specify the other has to be the initial issuer, right? So is it just that's how it's always been mostly, primarily speaking, interpreted, that others in that case really should be that initial issuer? Because it's not fair if, I think I heard Jake Travinsky give this example, Dogecoin can't be a security just because Elon Musk of his own accord one day decided to tweet about it. You can't not pass the Howey test because of that. But it is a little dicey because others, again, because though it's written just as others.
I think it would be difficult. Yes, there are others that could be contributing to the long-term value of a token or a token protocol or whatever that might be. But the securities laws is a regime that governs offer and sale, right? The 33 Act applies to the offer and sale of a security. And if somebody is tweeting about it, and they're not selling it, I think it would be very difficult to say that Elon Musk is causing the price of Dogecoin to go up, but he's not the issuer of it. And how can we hold him liable in that context?
Or hold anybody, say it doesn't, basically, how can we say it doesn't, that it, I never know if it doesn't pass the Howey test or it does pass. It doesn't, how can we say that it passes the Howey test and therefore it's a security?
Yeah, that's right.
Or it doesn't fail?
This is actually a ongoing debate. You want to pass, you do not want to satisfy all of the prongs of the Howey test. So whether that's a pass or a fail, it's hard to say.
Oh no, you've frozen for me.
Oh,
there we go.
Frozen? Oh,
keep going.
If you, it's an ongoing debate in the legal community whether winning is passing or failing. But basically, you do not want to satisfy all the prongs. So I suppose you've failed the Howey test if you don't satisfy all the prongs. And failing means we're not an investment contract.
Oh boy, this is the content.
This is what we lawyers talk about over drinks.
Okay, this is something that's haunted me as I've thought. Frankly, I spent a lot of time thinking about all this as I've tried to understand it. Because that decentralization piece feels really key to not satisfying the prongs of the Howey test and therefore not being a security. And if I look at something like Ethereum, it is a no-brainer to me that this fails the Howey test. First of all, the original issuer of Ether was a for-profit company that has subsequently been dissolved or whatever the phrase would be. And it is now, to the extent that you could say this, overseen by the Ethereum Foundation. It is very evident to me that if the Ethereum Foundation collapsed, Ether would continue to exist. Now, I do think Vitalik is important. If Vitalik got hit by a car tomorrow, I think it would affect the price of Ether, but it would not go to zero. Whereas if Meta, the original for-profit company that issued the stock, disappeared, the stock goes to zero because the stock is one-to-one correlated, again, let's forget the nuance, to Meta profits and Meta prices. And that's obviously not the case with Ether and the Ethereum Foundation. So I think when you're talking about the decentralization question, no doubt Ether to me, not a security. But then look at something like FTT. Or again, I don't know enough, frankly, about the nuances of XRP to Ripple to know if Ripple disappeared tomorrow, would XRP have value, do we think? And this is where I think it's a little tricky because to me, with most of these tokens, if they're going well, they're decentralizing more and more over time. But what is that moment in time when they officially decouple from the issuer. I don't know what FTT is worth right now, but I'm sure it's nothing, right? Nobody's buying FTT because FTX is gone. So you can't argue that FTT was a decentralized token, really. What was the effort of others propping that up other than FTX?
Yeah, without commenting on any specific tokens, like when are we decentralized is the million-dollar question, so to speak. That is a big part of what's going on with the review of the infrastructure bill, because the market infrastructure bill that's currently under review, the idea being they're trying to say when you are decentralized enough, you move from the securities regime to the commodities regime.
Commodities.
But that's very hard to determine. And and this goes to the challenge of it all, and even going back to the decision of Judge Torres, is it's a facts and circumstances based test. And the facts and circumstances that I think are important may not be the same ones that a judge thinks is important or that the SEC thinks are important. And so that's why, while this is certainly a win for the industry to have this ruling, and there's a lot in here, not least of which is just that SEC lost, and they had a pretty strong track record, and it also just shows that it's not as clear as anyone thinks it is, or as Chair Gensler would say that it is, if we have two judges in the same district in the same week coming up, or I guess the same month, coming up with different answers and different conclusions. But I think it goes to this idea that it is a facts and circumstances based test, which lends itself to 2020 hindsight, and which lends itself to are the facts the same with Ethereum as they are with a different token? Or how do we assess that if there's no Vitalik for that project? Or it's really, that is the $1 million question that we are all grappling with, and that will, I think, continue to be difficult when you have judge-made law and regulation by enforcement that just says the Howey test is the test. We don't need anything else. And I think that until we have something else that helps give that more clarity, we're going to be doing exactly what you're doing, which is wondering why this and not this.
Is there a set of rules that we could set up out front that could really set precedent and make this all really clear? Or inevitably, is there going to be X number of years of grinding through this in the court system? And maybe I'll phrase it this way. You referenced earlier this piece of legislation. I forget the name of it. Is it the one from the Senate? Or is it the one on the House?
The House.
This is the one on the House. Yeah, that's right. This is the
market infrastructure.
Okay, so this is this bill in the House that, as you just said, but just to make it clear for people, is basically saying that very initially, tokens will be regulated under the SEC, but that they will, as they work towards decentralization, and once they hit a point of sufficient decentralization, then they'll pass over and they'll be regulated like commodities, because at that point, they're no longer securities. Do you like that bill? I'd love to get your opinion. Do you think would that provide the clarity that we need?
Yeah, I think that is the right framework, so long as we can get some principles in place on what is decentralization and what is the off-ramp.
I think the security to commodity framework is right.
Exactly.
Okay.
Yeah. Because again, I think the examples that we've seen of the projects that have tried to go through the SEC process, I think they've just gotten stuck in it. And I think they're still stuck in it with no exit ramp. And so I think that's what's going to be really important, is making sure there is an exit ramp. But I do think, I think legislation is important. And I think that is going to be the best way through this. We could take years and years to try and figure this out through the judicial system. But I think that what we're seeing is that when you have a facts and circumstances based test, new technology, different facts and circumstances with every single thing, I think it's going to take a long time for us to find clear path and clear rules, because we have had cases in the past. There's been Kick and Telegram and others, but you look at those, and even with XRP and Ripple, the facts that they're alleging in many cases are many years old, and it's not how tokens are distributed in the modern era and with tokens that are launching now. And so even that has some limited value for guiding people today on what they can and can't do when you're basing it off of how it was done in 2015 or 2017. That's just not what people are doing necessarily in 2023. In 2017 and 18, DeFi wasn't even around yet. NFTs weren't around yet, things like that. And so it's not necessarily that helpful in applying that to the facts today. So I think that legislation is going to be a really important factor. Also important for kind of keeping up, I think, in the US, a competitive landscape, because if you continue to have this level of uncertainty, while others are seeing the opportunity, other jurisdictions are seeing the opportunity to say, what if we had a real principles-based system? People are seeking those jurisdictions out already. And if you give it too much time here, I think people are already growing very frustrated with that.
Yeah.
It's also limiting. There are certain projects and certain founders that are simply not willing to come in. They're not willing to take on that risk. They're not willing to take on that reputational risk. And that's really unfortunate for everybody.
What would be the ramifications? How would it work if tokens moving forward were initially securities and then would move to commodities? Is it something where we maybe wouldn't see so much secondary activity, or we wouldn't see like trading on them in those early stages, but once they're commodities they could? Or is it just that like then you would need something like a Prometheum that could legally trade securities in some form? Like they would have to register and go through that whole process in the beginning, and we'd have some sort of like securities exchange they'd be traded on until ultimately they can move over to other exchanges.
I haven't looked at the markup and things like that, so I don't actually know. I'm not clear actually on how they intend to trade in that transition
scenario.
So.
Okay, so let's forget about it. So one thing I'm a little bit hung up on is this Orange Grove investment contract analogy we've been using. And because the investors in the Orange Grove are expecting profit because they're expecting the Orange Grove planter to go off and sell oranges and give them money back. These early investors in these projects who are expecting tokens down the line, are they also getting equity in the companies? Like where do they expect their return to come from when they sign that SAFT or that warrant or whatever?
So SAFT, you're just getting tokens. So SAFT is a simple agreement for future tokens. It is simply that. It is a forward purchase agreement that says, I'm giving you this money now, and you're
So it's a forward purchase agreement. Okay, that's what you mentioned earlier, and that matters.
Yes. Yeah, so you're giving them money now for delivery of tokens when they launch the protocol and launch the project.
So is a forward purchase agreement, it is an investment contract, but it's a specific kind of investment contract?
Yes, it's a contract. And so the underlying facts of what's happening at the contractual level are what makes something an investment contract.
Taking a step back, in some ways what I think everyone agrees on, except for the really bad actors, is that we want to keep retailers safe. And there's obviously been a lot of problems with the existing system, with retailers getting burned. I certainly think that FTX should have had a bunch of disclosures, or there should have been more visibility into that. Point to whatever you want to point to. Now, they were, of course, not even in the US, so our law wouldn't apply anyway. But point being, like, this disclosure thing Gary talks about a lot as being like at the core of all of this, which in the abstract sounds really logical. What I would love to understand a little bit better from you are, under existing securities frameworks, like what are the disclosures that are required that may or may not really be applicable to crypto?
Yeah, and this is, I think, the real challenge and the issue here is that if you think about a typical company about to do an IPO, their disclosures are description of their business. Sure, that makes sense. We can describe our business. Risk factors. Okay, risk factors, that's easy. But then they go into their financial statements. Does that really matter to a purchaser of crypto, what the financial statements of the entity are? Executive compensation, the list goes on and on. A lot of these things are already publicly available to a lot of for people to access via blockchain. Material contracts is also a weird disclosure in that there are no material contracts necessarily in the crypto space. Also, there's this concept of current disclosures of here's an important event that happened that we want to disclose to the market so the market can absorb that information. But when you have a decentralized network, there could be 100 different people that are doing things that might be material. So whose obligation is it to report material information? And particularly as the issuer, so to speak, do you even know what and when those things are happening? I think the point is I don't know that the current Form S1, which is what you see when you get the public offering IPO registration statement, is necessarily the information that's material and important to somebody who's buying into a crypto ecosystem, or somebody is, more importantly, the users, right? If you're a validator or something like that, what do you really need to know if this is the platform that you want to build upon and start accumulating those tokens?
Yeah, I'm interested in this on a couple of levels. One, I'm interested in helping people understand what is meant when we talk about disclosures. And you talked about the things that are required that may not fit or make sense for a crypto company. And I want to drill down on one of those in a minute. But that's to say nothing of the things that aren't included that would actually probably do a better job of protecting retailers, whether it is tokenomics or whether it is, like, there's any number of things that we actually would maybe want to add to a disclosure form on crypto to better protect retailers. I want to drill down on the revenue piece that you just mentioned, because financials, you mentioned that in a traditional IPO, let's say, a company obviously has to disclose their financials. And that's probably the most important thing that any investor is going to look at when debating buying a stock is, okay, what do the financials of this company look like? There's plenty of other factors, right? Because again, back to that thing I mentioned earlier, which is when you're buying a stock, in simplest terms, it is very correlated to the profit there. I think what's interesting, because I've thought about this now, when I think about crypto, and I gave the FTX example earlier, clearly there's an extent to which, depending on how centralized or decentralized the coin is, you do want to know, is this company about to go bankrupt? There's like a very binary level to which you want to understand the financials. But again, first of all, to your point, probably revenue to the Ethereum Foundation is mostly going to be found on the blockchain. It's already public anyway. But again, I don't buy Ethereum in any way because of how much money the Ethereum Foundation is bringing in, or I don't buy Ether because of how much money the Ethereum Foundation is bringing in. I think it's really important for people to understand, because even for people outside, I think especially people outside of the crypto ecosystem, I think you might be like, of course you're going to care about the financial standing of Ripple. But no, again, XRP is trading on so many factors. And this is what Judge Torres did understand. General crypto market sentiment is going to drive these prices. There's a lot that's going to drive these prices that is completely independent from Ripple's financials, which is just not true in the case of any of these stocks. But I'm curious, because now understanding this framework better of within the construct of securities, is that do all securities, so notes, investment contracts, stocks, all the things, that list we went through at the top of this episode, do all of them have the same disclosure requirements?
If they are doing their offering and seeking listing on a public exchange, on a registered exchange. So if you're doing an IPO, then yes, they all have the same Form S1 disclosure requirements. Other times, maybe if you're not doing the direct listings, for example, you're still doing a resale offering. It is all the same disclosure. Yeah. Also, there's a world in which you could say some people become just public companies are filing 10Ks and 10Qs and things like that. There's a different regime for Reg A. It's a little bit more reduced. But if you are doing this offering on a public basis, then yes, you have to provide essentially the same disclosures, with one caveat, which I think is really important, is that the SEC has actually recognized in the past a certain type of transaction, a type of security benefits from a different type of regulatory regime, and that's Reg AB, that's asset-backed securities. So they actually looked at those asset-backed securities and they said there's an entirely different set of disclosures that we think are important for purchasers of this. We are creating a new regulation, Reg AB, and then new forms pursuant to which asset-backed security issuers will make disclosures on that basis, because it was very different kind of material information that the investors would want. So there is history of creating a more tailored regime rather than just fitting a square peg in a round hole.
I think there's a lot more we could dive into and want to dive into, maybe even a little bit around Prometheum, or certainly around Prometheum, because around exchanges. And this almost gets us then into the Coinbase and Binance side of things, which is this idea that they're illegal securities platforms and they're doing illegal security offerings. I don't think we have time for all of that today, which is where I think we may do a part 2 of this that really goes into the exchange side of these laws and what are the implications once you've established security or not security. What are the implications there in terms of where we as retailers come into all of this? But maybe to close this part 1 of all this, I have a couple questions. One you're probably going to demur against or whatever, but do you feel like you have advice, or you for, and not actual formal legal advice, but just what is your perspective on how a company interested in issuing a token now should go about it based on what we have from the Judge Torres ruling, the Judge Rakoff motion to dismiss, whatever that was? Where do you feel like folks should land?
Gosh, that's a hard one to be on the spot. I think generally what I think maybe the unfortunate takeaway is that not a lot has changed. We're still in a world where one judge can look at a set of facts and circumstances and find it to be an investment contract. And even with the same asset, find different forms of offer and sale to be and to not to be investment contracts and
that is the question.
Transactions.
Okay.
And I think, and then you can have a few weeks later, another judge come to a different conclusion. And so I think that we are still in this world of divining and reading tea leaves. We get bits and pieces from these decisions where we can try and draw analogies where we can. And I think it is very positive, right? It is positive to see where Judge Torres came out, because I think ultimately these are the right results. And I think also there was a lot in there about secondary market trading, which, you know, is really the important piece for cryptos, is being able to have trusted and liquid and high volume trading markets for people to access these tokens across the world and whatnot. So I think that it's just hard for me to say necessarily what the right.
We don't really have an answer still. Yeah.
I think that's right.
Do you think it holds up against an appeal, Judge Torres' ruling?
Oh, I don't know that I like to make predictions.
Fair enough. Because I'm a little nervous.
Yeah, I think we're all a little bit nervous, but I think that she's applied the Howey test. I think I'm hopeful that what will hold up is what we started at the top of the podcast with, which is that the tokens themselves are not embodiments of anything. You have to establish the prongs of the Howey test in connection with every offer and sale to say that it's an investment contract and therefore the securities laws apply. And that would be a real win. Now, again, like I said, it puts us in this place where we're still in a facts and circumstances based test. But I think that this concept that is being espoused by the SEC and others, that the token itself is a class of security that is registered as a crypto asset security, which is certainly not in that list of enumerated securities that I listed off at the beginning of our discussion. That is not. That is a bad result, right? Because it gets to a world in which every single transaction continues to be a securities transaction, and that's just not the right result. It's not the right case for the growth of this technology and for the operation of this technology. You cannot have a programmatic distribution of a mining reward or a staking reward be viewed as a securities transaction. That just is not feasible, for example.
And I think the win here, obviously we don't yet have clarity and we haven't solved the problem at this point, but the win, which you pointed out earlier, is maybe a philosophical one, which is that this has established that existing laws are not clear enough to settle this issue. And that has been, I think, the frustrating thing where many of us feel like we're being gaslit by the SEC or Gary Gensler or Prometheum, who want to act like this is all very clear, very simple. And what are you talking about? Of course, we can use existing securities laws and existing securities regimes to do this. And y'all are just a bunch of Wild West cowboys that are trying to break the law willfully, because it's actually very clear. And when it's especially being said in that tone, like quite literally by some people, you're like, I'm not crazy. This is actually complicated and more nuanced than that. And at a very minimum, if we get nothing else, we have gotten that out of Judge Torres' ruling is, okay, look, we have a judge who is clearly siding with us in such a way that suggests this is not all clear and solved. And so we do need new legislation. The last question I was going to ask, which is maybe a silly question to even start diving into, but hell, we're here, is just, obviously we're a more NFT focused podcast and we spent today talking exclusively about fungible tokens. I'm not necessarily optimistic about where all this lands for non-fungible tokens, where I think the kinds of creative things that we sometimes want to be able to do with non-fungible tokens, which is bootstrap an author or bootstrap a musician's career, where we then get some level of profit later down the road when they're really popular. As I've learned more about this, I'm like, that feels like it pretty strongly passes the Howey test. That's all the prongs feel like they're there. That's the Orange Grove contract. And we haven't even gotten to any of that in court because they've way bigger fish to fry. But would that be your read on that situation as well?
No, I think in as it relates to NFTs, I think that there is a lot more to explore on what they can do and how they can be used. But yeah, I think you still have to keep. I think the point here is that the investment contract analysis is the applicable analysis, whether it's an NFT or no matter what it is. And again, whether it's an NFT or an orange or a whiskey receipt or a chinchilla, things like that. They're all kinds of animals that people have turned into investment contracts essentially. But yeah, so you still have to apply that framework, I think is the overall lesson that I think we knew and now have been affirmed.
Here's the last question I have, and I knew I was going to do this and just keep asking you questions even after I said it was going to be my last question. I think last time you came on, as we prepped for that, you mentioned Matt Levine. So I think you're a Matt Levine reader. I'm definitely a Matt Levine reader. And his big piece after the Ripple verdict came out was really centered on what we got to earlier, which was this idea that by Judge Torres's logic, stocks that buying a stock off the exchange, off the NASDAQ, whatever, stock exchange, wouldn't be a security because you're not buying it from Meta directly. Meta's not profiting off of it, whatever. What do you make of that article now, me understanding that these are two separate, an investment contract and a stock are two separate prongs in this list of things that are securities? Did he just miss that? What do you think he was getting at with that piece?
Yeah, I do think this is a common issue, like even amongst securities lawyers, where you want to think of it as the transactions are all the same and the thing is all the same, but you have to establish that it is a security in order for then Judge Torres's the concepts to apply. So I think that maybe it's possible that he did miss that concept, right? Stock is always a securities transaction. We don't assess and evaluate who gets the money and how it's being traded. But I do think maybe what he was also getting at, though, is this idea that just because you're buying it off of an exchange and money isn't going to Meta, to that point that we talked about earlier, which is that doesn't mean that people shouldn't have the protections of and the benefit of the disclosures and securities law protections. But I do think maybe I should write him a note.
You should. Now I want to have Matt on. I love Matt Levine so much, and I think he's such a good writer, and I really value his take on things in a lot of ways. And now this makes me want to have him on and be like, answer to this. How did this? I don't know that.
Even amongst my own partners, it was somebody posed that question. How is that possible? That means that an LP interest in a fund would originally be sold as a security and later not be sold as a security. And then the answer is no, that is always a security. A limited partnership interest in a fund is always a security.
Because it's enumerated in that list.
The manner of sale. Yeah.
Karen, this was so wonderful as always. Thank you for walking me through all of my ridiculous machinations trying to understand all of this. And we'll have you back again. There's so much we didn't even touch here, but I'm I didn't want to touch new categories looking at the clock being at the 60-minute mark. So we'll have to bring you back.
Yeah, of course. I'd be happy to do it. It's not easy, as we're seeing from the judges in the Southern District of New York. It's not simple.
Totally. And it's not easy to talk about it. I told you this was the hardest episode I've ever tried planning. I was I don't even know what's about to happen because it's too hard to wrap your head around it all and know how to give the right amount of context. And so I really appreciate you working through it with me.
Of course. Happy to do it.
Thank you so much for watching this episode of Overpriced JPEGs. If you liked this conversation, if you liked this episode, please go ahead and hit subscribe. It helps me out, it helps the show out, and it means you will get alerts and updates when we post new content. Thanks again.